Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Today we're bringing you a special collaboration with Little Legal Summaries, written by Sarah Little. May 2021 recap. Here are our picks for some of the most impactful cases from the Court of Appeal for Ontario, published in May 2021. The Queen and Anderson, 2021 ONCA 333. In June 2018, the appellant was found not criminally responsible on account of mental disorder, NCRMD, by Justice Stone of the Ontario Court of Justice in relation to charges of arson, unlawful confinement, assault with a weapon, and mischief. The appellant raises a single ground of appeal, that he did not appreciate the nature of the proceedings that resulted in the NCRMD verdict. The appellant alleges that a miscarriage of justice occurred because the trial judge failed to explain the process of an NCRMD plea to him and to conduct an inquiry to ensure his admission was voluntary and informed. He alleges that he did not understand the meaning, process, or repercussions of an NCRMD finding, and that he did not intend to accept the facts based on evidence adduced at the preliminary inquiry. In this case, the appellant elected to have a preliminary inquiry followed by a jury trial. Following the preliminary inquiry, the appellant was remanded to 60 days in a mental health facility for an assessment report to be completed. Following the 60 days, the appellant re-elected his mode of trial to be tried in the OCJ before the preliminary inquiry judge, Justice Stone. At trial, the appellant entered a plea of not guilty. The Crown relied on evidence of the preliminary inquiry and invited the trial judge to find the appellant committed to the impugned acts on that basis, but to find the appellant NCRMD based on the assessment report. The defense did not make any submissions or call any evidence. The trial judge found the appellant not guilty of 2 counts, but entered a verdict of NCRMD on the other counts, referring the matter to the Ontario Review Board for a disposition hearing. NCRMD and guilty pleas. Where an individual has a mental disorder that deprives them of the capacity to form criminal intent, they may be exempt from criminal liability. In other words, if a mental disorder deprives the accused of the capacity to appreciate the nature and quality of their conduct, or of the capacity to know that their conduct is morally wrong, the accused lacks the necessary criminal intent to be convicted. Due to the lack of criminal intent, mental disorder operates as an exemption from criminal liability. See Section 16 sub 1 of the Criminal Code. There is no special plea of not criminal responsible on account of mental disorder. Where an accused enters a general plea of guilty, governed by Section 606 sub 1, Section 606 sub 1.1 requires the judge to conduct a plea inquiry to ensure that the guilty plea is voluntary, informed, and unequivocal. The failure to conduct a full plea inquiry, however, does not necessarily invalidate a plea. Section 606 sub 1.2. There is no equivalent inquiry when an accused pleads not guilty. When an accused pleads not guilty, it puts the Crown on notice that they must prove each element of the offense beyond a reasonable doubt. It is a denial of the alleged acts and does not amount to an admission of any of the essential elements. See the Queen and PR 2013 ONCA 53 at paragraph 41. Having reviewed the history of the proceedings, the Court of Appeal was satisfied that nothing occurred to compromise the overall fairness of the proceedings or the appellant's ability to understand the NCRMD verdict. The appellant was represented throughout by competent defense counsel who advised the appellant at each stage of the proceeding what to expect and potential consequences whether they proceed to trial proper or pursued the NCRMD route. Similarly, prior to ordering the assessment report, the trial judge explained to the appellant that the purpose of the report was to determine whether he was exempt from criminal responsibility for these offenses on the basis of mental disorder. The appellant was given ample opportunity to review the report and to make an educated choice as to whether to proceed to trial or to raise an NCRMD defense. The appellant advised trial counsel that he wished to proceed with the NCRMD route. The trial judge was not required to conduct a plea comprehension inquiry under Section 606 sub 1.1 in the absence of a guilty plea. The Court of Appeal, however, notes that it is preferable for trial judges to conduct such an inquiry at the outset to ensure that the individual is aware of the nature and effect of the NCRMD procedure. The appeal is dismissed. The Queen and Chambers, 2021 ONCA 337. The police found drugs in the appellant's bedroom in an apartment she shared with her adult son. The appellant was arrested away from the residence shortly before the execution of a search warrant. The appellant was tried by a judge and jury. The sole issue at trial was whether the Crown could establish that the appellant had knowledge of the drugs found in her bedroom. The defense's theory at trial was that it was a reasonable inference that her son moved the drugs without knowledge when the police gained entry to the residence. On appeal, the appellant argues that the trial judge erred in admitting an officer's opinion evidence about the appellant's demeanor and in failing to instruct the jury to disregard the same. At the outset of trial, the Crown sought to have demeanor evidence admitted by having various witnesses attest to how the appellant behaved at the time of her arrest. The trial judge ruled this form of opinion evidence was inadmissible. Regardless, throughout the trial, several officers testified about the appellant's demeanor both at the time of her arrest as well as at the residence during the search. They testified that she seemed very nervous, very agitated, not answering the questions asked of her, appeared to be a deer in the headlights, etc. At the pre-charge conference, defense counsel raised the issue of demeanor testimony. The trial judge admitted they regretted letting it in as it was akin to post-offense conduct and that he would advise the jury to be very reluctant to rely on this form of evidence. In addressing the demeanor evidence in his charge, the trial judge indicated that this type of evidence does not really help you, the jury. The charge was deficient. Merely telling the jury that this type of evidence does not really help still leaves the jury free to apply their own view of it and leaves open the risk that they will improperly rely on the evidence. The trial judge should have instructed the jury unequivocally to disregard the evidence. Similarly, the charge lacked the clear instruction that the jury was not permitted to make any conclusions from the appellant's refusal to answer the police's questions. These types of deficiencies render the trial unfair and require a new trial. The Queen and Griffith, 2021 ONCA 368. Where an individual does not have sufficient means to fund their own appeal and is denied funding from Legal Aid Ontario, they can apply pursuant to Section 684 of the Criminal Code for court-appointed counsel to assist with the appeal. Mr. Griffith qualified for legal aid based on his income, but was denied as Legal Aid Ontario concluded his appeal lacked sufficient merit. As a result, he applied to the Court of Appeal for a Section 684 order. Section 684 Orders. Section 684 of the Criminal Code authorizes a Court of Appeal judge to assign counsel to represent an accused in a criminal appeal, funded by the Attorney General if 1. Legal aid has been denied, 2. The accused lacks sufficient means to hire counsel, and 3. Where it is in the interests of justice that the accused should have legal assistance. In order to obtain a Section 684 order, the applicant must show, see the Queen and Budla Cody, 2021 ONCA 163 at paragraph 14, the appeal is arguable and not frivolous, this is a modest threshold, and it is necessary that counsel be appointed having regard to whether the applicant is capable of effectively advancing his grounds of appeal without a lawyer, and whether the court can decide the appeal without counsel's assistance. The court may consider the complexity of the legal arguments to be advanced on appeal, as well as the applicant's ability to make those arguments. The Court of Appeal also makes note that the potential assistance of the pro bono inmate appeal duty counsel programs does not detract from the need for funded counsel. Pro bono duty counsel are not a substitute for funded counsel, whether through legal aid or Section 684, where circumstances warrant counsel's assistance. See also the Queen and Lubin, 2016 ONCA 780 at paragraph 18. The Queen and Zamora, 2021 ONCA 354. This case provides a helpful overview of the basic principles relating to the role of a preliminary inquiry judge and a reviewing judge in a certiorari application. A preliminary inquiry judge's jurisdiction stems from Section 548 sub 1 of the Criminal Code, which reads as follows. Order to stand trial or discharge. 548 sub 1. When all evidence has been taken by the justice, he shall, sub A, if in his opinion there is sufficient evidence to put the accused on trial for the offense charged or any other indictable offense in respect to the same transaction, order the accused to stand trial, or, sub B, discharge the accused, if it is his opinion on the whole of the evidence no sufficient case is made out to put the accused on trial for the offense charged or any other indictable offense in respect to the same transaction. The role of the preliminary inquiry judge is to determine whether there is sufficient evidence to permit a properly instructed jury, acting reasonably, to convict. This does not require the judge to assess credibility or draw inferences from the facts, as this is the role of the jury. Where evidence is circumstantial, however, the preliminary inquiry judge must engage in a limited weighing to determine whether the evidence, if believed, could reasonably support an inference of guilt. If more than one inference may be drawn from the evidence, only the inferences that favor committal are to be considered. If the evidence could result in a conviction, the accused must be committed. The leading case in this area is the Queen and R. Curry, 2001 SCC 54. Where a preliminary inquiry judge acts outside this jurisdiction, for example, by engaging in impermissible weighing of the evidence, they commit a jurisdictional error. CMM and United States of America, 2015 SCC 62. Following the preliminary inquiry, the judge will either commit the accused to stand trial or discharge the accused. If a party believes the preliminary inquiry judge exceeded their jurisdiction in committing or discharging the accused, they can bring a certiorari application to review and quash the preliminary inquiry judge's decision. The reviewing judge's role on certiorari is limited to whether the preliminary inquiry judge exceeded or declined to exercise their jurisdiction in arriving at that decision. It is not the reviewing judge's role to redo the preliminary inquiry's weighing or analysis, or to determine the correctness of the preliminary inquiry judge's decision. The reviewing judge's decision can then be reviewed on appeal to the Court of Appeal for Ontario. The Queen and Tenthori, 2021 ONCA 324. The Court of Appeal provides much-needed clarity to the law on included offenses. The accused in this case, Mr. Tenthori, was convicted by a jury of aggravated assault. He appeals this conviction on the basis that the trial judge erred in failing to instruct the jury on the included offenses of simple assault and assault causing bodily harm. In support of this argument, he relied on Section 662 sub 1 of the Criminal Code, which provides that a person charged with an offense is in jeopardy of being convicted not only of the charged offense, but alternatively of any included offenses. Tenthori argued that simple assault and assault causing bodily harm are lesser included offenses in a non-particularized charge of aggravated assault. Non-particularized meaning a charge that does not specify the mode of committing the aggravated assault, wounding, maiming, disfiguring, or endangering the life of another. The crux of his argument that had the jury been instructed to this effect, they may have found him guilty of one of the lesser offenses, rather than the more serious offense of aggravated assault. Lesser included offenses, governing principles. As a matter of fundamental justice and fairness, an accused person is only called upon to meet the charge put forward by the prosecution. See the Queen and Gr. 2005 SCC 45. This is because an accused is entitled to fair notice on the charges they face. An offense is therefore an included offense if it forms part of the charged offense. The Queen and Gr. 2005 SCC 45 has long been cited as the leading case articulating the test for determining included offenses. GR holds that a lesser included offense is one that is necessarily committed to the commission of the principal offense. In reality, however, the test as stipulated in GR is only workable for offenses where there is a single mode of commission. Where there are multiple modes of committing the charged offense, an offense will be deemed an included offense if it is necessarily proved by establishing any one of the different ways which the charged offense can be committed. For example, the Crown may establish a non-particularized aggravated assault by proving that the accused maimed, wounded, disfigured, or endangered the life of an individual. 3 of those modes, wounding, maiming, disfiguring, necessarily cannot be committed without also committing an assault causing bodily harm. As such, ABH is a lesser included offense of a non-particularized charge of aggravated assault. To avoid this confusion, Justice Paciocco proposes a new test for determining whether an offense is an included offense, regardless of whether there is a single or multiple mode of commission. At paragraphs 51 and 58, quote, "An offense will be an included offense if the essential elements of that offense would necessarily be proved if the Crown were to successfully establish any one of the legally available avenues of conviction for the charged offense." End quote. Included offenses, jury instructions. Even when an offense is deemed an included offense, trial judges are not required to instruct a jury on the law applicable to that offense unless there is an air of reality to the evidence at trial to permit a reasonable jury, properly instructed, to conclude that the essential elements of the included offense have been established. See the Queen and Luciano, 2011, ONCA 89. The purpose of this threshold is to ensure that trial judges do not encroach on the role of the trier of fact. In assessing whether there is an air of reality to a jury having a reasonable doubt on the charged offense, but to convict on an included offense, the trial judge should not consider how likely or unlikely they believe that outcome to be. Similarly, the trial judge should not pay regard to concerns about the credibility or reliability of the evidence required to reach that outcome. An included offense must be left with the jury where there is either 1, direct evidence, or 2, sufficient circumstantial evidence that yields logical inferences in light of human experience and common sense that the accused has committed an included offense, but not the charged offense. The Queen and Citladine, 2021 ONCA 303. The appellant, Mr. Citladine, is a black man who was pulled over for suspected impaired driving. He was wrongfully arrested for driving while suspended. When the officers searched him incident to arrest, they discovered a loaded firearm. He was convicted of possession of a firearm. At trial, the appellant's position was that the stop and subsequent arrest were unlawful due to racial profiling. As a result, he sought to have the firearm excluded from evidence under Section 24(2) of the Charter. The only issue on appeal is whether the trial judge misapplied the test for racial profiling by requiring a finding that the police lied about the reason for the stop and arrest. Background. The stop occurred shortly before 3 a.m. on March 5, 2017. The appellant was driving a rental vehicle. He was not speeding. Officers Delmar and King observed him activate his right turn signal, enter the right turn lane, but not turn right. Instead, the car swerved back into the other lane without signaling. They suspected the appellant was impaired. The officers pulled up beside the appellant, shone a light into the driver's side of his car, and saw that the appellant was a young black man alone in the car. They activated their emergency lights and directed him to stop. The appellant had not been drinking, and the officers could not detect a smell of alcohol. The appellant could not produce a driver's license, ownership, or insurance documents. PC Delmar asked the appellant for his name. The appellant provided his brother's name, Donovan Citladine. PC Delmar misspelled the appellant's name in CPIC, which resulted in a search result identifying an individual with a suspended license, subject to a weapons prohibition and who was known to be armed and dangerous. This prompted PC Delmar to inquire further about the appellant's identity, who now identified as Damian Citladine. The officer made the same typographical error, which returned a result with no photograph, which was unusual. A third officer, PC Statham, arrived at the scene. The officers arrested the appellant for driving while suspended. As the appellant exited the car, a struggle ensued which revealed a gun in the appellant's waistband. At the trial, the main issue was whether the stop, arrest, and/or search were tainted by racial profiling. In applying the racial profiling test as articulated in the Queen and Brown, 2003 ONCA, the trial judge concluded that the finding that the officers lied was a crucial element in establishing racial profiling. The trial judge reviewed the officers' notes and will say statements, as well as the officer's evidence relating to the stop and arrest. In doing so, the trial judge concluded that the arrest and search were not racially motivated, as there was insufficient evidence that the officers were lying about why they conducted the stop and arrest. Racial profiling, general principles. Definition of racial profiling. The Queen and Brown, 2003 Ontario Court of Appeal, at paragraph 7. Racial profiling is criminal profiling based on race. Racial or color profiling refers to that phenomenon whereby certain criminal activity is attributed to an identified group in society on the basis of race or color, resulting in the targeting of individual members of that group. In this context, race is illegitimately used as a proxy for the criminality or general criminal propensity of an entire racial group. The attitude that underlies racial profiling may be consciously or unconsciously held. Consequently, a police officer need not be an overt racist to engage in conduct based on unconscious racial stereotyping. The existence of the phenomenon of racial profiling by police is well established and supported by significant social science research. Racial profiling claims are rarely proven by direct evidence, as this would require an admission by the officer that racial stereotypes influenced the decision to stop the accused. Accordingly, if racial profiling is to be proven, it must be drawn by inference drawn from circumstantial evidence. An inference of racial profiling can be drawn where there is evidence supporting the argument that the officer was not being truthful about the real reasons for the stop. This is often referred to as the correspondence test, where the evidence shows that the circumstances relating to a detention correspond to the phenomenon of racial profiling and provide a basis for the court to infer that the police officer is lying about why he or she singled out the accused person for attention. The record is then capable of supporting a finding that the stop was based on racial profiling. In Pert and Peel Regional Police Services Board, 2006 Ontario Court of Appeal, Appeal Justice Doherty held that one way to prove racial profiling is to compare the facts with indicia of racial profiling to provide a basis for an inference that the officer is untruthful as to why the accused was signaled out. The Court of Appeal in Sitladine makes clear that the correspondence test is not necessarily focused on whether the officer was lying, but whether the circumstances of the case give the court a basis to reject the officer's evidence as untrue because they are indicative of racial profiling. This is consistent with unconscious bias. Some officers may unconsciously allow racial stereotypes to influence their decision to detain, stop, arrest a racialized individual. The officer may not be consciously lying about his motivation, but this does not mean he did not engage in racial profiling. In the Queen and Lee 2019 SCC 34, the Supreme Court commented that racial profiling occurs when race or racial stereotypes are used, either consciously or unconsciously, and to any degree in the selection or treatment of a suspect. In the Queen and Duddy 2019 ONCA 665, the Court of Appeal held that even where an officer has objective grounds to detain an individual, those grounds cannot justify the decision if they are tainted by any degree of racial profiling. Quote, "It is the role of the trial judge to consider all of the circumstances that led to an accused detention and or arrest and to determine whether they correspond to the phenomenon of racial profiling. The trial judge can then decide whether the corresponding circumstances form a basis to infer that the record is capable of supporting a finding that the stop was based on racial profiling." End quote. In other words, contrary to the trial judge's finding, a trial judge is not required to find that a police officer who testifies that race played no role in the decision to arrest or detain was lying. Dissent, Appeal Justice Miller. This case is one to watch. With Appeal Justice Miller dissenting, it has an appeal as of right to the Supreme Court of Canada, where the SCC will have an opportunity to weigh in on this timely and important topic. In Miller's view, the majority has in essence created a rebuttable presumption of racial profiling whenever an officer becomes aware of the racial identity of a suspect when making a traffic stop, which is a substantial and unwarranted departure from the existing jurisprudence on racial profiling.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.